May it please the Court, my name is Henry Initial C, and I appear for the defence on behalf of the accused, Mr Marshall Ike. Your Honour, I submit by way of Section 590, capital AA of the Queensland Criminal Code, that my client's admissions to police in relation to the 85 charges made out against him should not be admitted as evidence in his prosecution. This includes Mr Ike's responses both during the record of interview and prior to the record of interview. My submissions rely on Section 130 of the Queensland Evidence Act 1977 that confers statutory power on the Court to exclude evidence against Mr Ike if it is satisfied that it would be unfair to Mr Ike to do so. Your Honour, I submit that the evidence obtained from my client is inadmissible in reference to discretionary powers used to exclude evidence, firstly under considerations of fairness and secondly under public policy considerations. Further, I wish to bring to Your Honour's attention that my client is of Torres Strait Islander heritage and is a child as defined under Section or Schedule 4 of the Queensland Youth Justice Act 1992. Turning to my first submission, the defence seeks to exclude the admissions made by Mr Ike to police under the fairness or Christie discretion. My client's admissions may be excluded if the probable effect as evidence would be disproportionate to its true evidential value, as confirmed by the Crown and Lee. This is further clarified by the Crown and Hasler, where Justice Thomas propounds that exclusion should only occur when the evidence is of relatively slight probative value and the prejudicial effect of its admission would be substantial. The defence admits that the probative value of Mr Ike's admissions to police is of slight substance and would substantially prejudice our client's right to a fair trial. This is due to the police's failure to acknowledge and navigate the gratuitous concurrence that occurred when my client spoke with police, exhibited by his avoidance of the officer's direct questioning style and his lack of eye contact. The initial question asked by the police, "These aren't yours, are they, mate?" was suggestive of a negative answer. The police further lessened the probative value of the evidence by failing to adhere to procedural requirements, but I will address this in more detail later. Gratuitous concurrence occurs where a person agrees with what is put to them in order to appease, irrespective of the truth, and often as a result of intimidation or misunderstanding. These answers are unreliable, as they are intended to demonstrate respect and cooperation over honesty. Your Honour, it is not unusual for a person of Aboriginal or Torres Strait Islander heritage to answer positively to questioning made by people in position of power, such as in my client's situation. My client's vulnerability is only further reinforced by his age and maturity. To answer yes to 84 counts of breaking and entering is an obvious example of gratuitous concurrence, and it's defence's submission that this is why Mr Ike answered the police's questions in the way that he did, and this evidence is inadmissible on this basis. Moving on to my second submission, my client's admission should be excluded as evidence as the police failed to comply with the Police Powers and Responsibilities Act and the corresponding regulations. I submit that it was reasonably practicable for the police officers to have adhered to the following provisions, but they simply failed to do so. Firstly, the police failed to caution my client about his right to silence in a way that substantially complies with the Item 26 of the Police Powers and Responsibilities Regulations, as required by Section 431, subsection 1 of the PPRA. The police approached my client and immediately began questioning him, and there's nothing to suggest that they made any attempt at ensuring that he understood his rights or that anything he said could have been used as evidence. The police did not make it clear to my client that he was a person of interest in relation to the commission of an indictable offence, as stipulated under Section 391 of the PPRA. Secondly, Section 418, subsection 1, sub A and B of the PPRA permit that my client should have been informed of his right to contact a friend or relative to inform them of his whereabouts or request their presence during questioning, or to contact a lawyer before police questioning commenced. My client was not allowed this. Thirdly, as a Torres Strait Islander, albeit not an adult, the officers failed to adhere to the broad principles outlined in Section 420 of the PPRA, and that they should have notified a legal aid organisation of my client's custody situation and informed Mr Ike that a legal aid organisation had been contacted. Fourthly, there is no doubt that the police suspected that my client was and is a child, and as such, Section 421 of the Act applies and states that the police should have allowed him an opportunity to contact a support person of his choice prior to questioning. While a social worker was provided at the police station, it was not a person of my client's choosing, and questioning had already commenced at that point. The only support the social worker provided my client was to direct him to answer the police questions. Fifthly, my client's admissions in the police car were not electronically recorded. There are no reasons on the fact that indicate that it wasn't practicable for the police to have done this. My client did not immediately confess to committing the offences, and presumably the police have the same access to recording facilities during initial questioning as they did at the station. Further, the transcript of my client's recorded interview showed that some of his responses were inaudible, and therefore the evidence can be excluded under sections 436 to 439 of the Act. Your Honour, I refer to the common law discretionary test to exclude relevant evidence as set out in Bunning and Cross that reinforces the only discretion. Firstly, we submit the officer's breaches cannot be characterised as mistakes. Given the number of breaches and that they did not fulfil what are basic responsibilities of police officers, they showed a clear and reckless disregard for the law. Secondly, as there is no other evidence to support my client's admissions, which we must remember were influenced by gratuitous concurrence and are therefore unreliable, evidential cogency is relevant. Thirdly, as I've already stated, there is nothing to suggest that the officers were responding to present circumstances that warranted their non-compliance. Fourthly, my client's admissions were made regarding offences with much less gravity when compared with serious offences like offences against the person. Finally, Section 5, subsection E of the PPRA states that the purpose of the Act is to protect vulnerable persons like my client, whom police officers exercise power against. Section 439 of the Act provides that a court may only admit evidence if it would be in the interest of justice. Your Honour, the defence admits that it would not be in the interest of justice to admit this evidence because of the police's failure to comply with the PPRA even when practicable. Respectfully, Your Honour, if it pleases the court, on this basis and in consideration of the fairness discretion, the Crown's evidence must be excluded. Thank you, Your Honour.